Yes. Good evening, Foxians and all those who have joined today for today's 107th podcast, Gyan Pravah, started by our beloved Fogsi President, Dr. Sunita Tandulwadkar. This podcast mainly aims that our Foxians come to know different faculties who are working in different fields so that not only our academics, but some social commitment, social devotion is also expressed through this podcast. Through this podcast, we have had many distinguished faculties all over the world, not only in India, but all over the world. So today is our 107th podcast. Before we start our podcast, let me introduce our dynamic, dedicated, and disciplined President Fogsi, Dr. Sunita Tandulwadkar. She is the President Fogsi 2025, Founder President Society of Ovarian Rejuvenation 2023, President-elect ISAR.
Alka, the podcast is about you and justice. Alka, the podcast is you and sir. So
Yes.
don't give me so much of introduction. I appreciate you.
Thank you so much,
We
Sunita.
are more interested in hearing sir. And I'm so glad and I welcome you on a Foxy platform. It's really thanks, Alka, for getting such a phenomenal faculty every time. Last time she got us Nitin Gadkari himself. So, and there was so much more to learn from every one of you. So, I'm eager to hear the podcast. Our pattern is, sir, only two of you will be in the frame, and I'll be joining the viewer link once she introduces here. I just joined to welcome you and just to show our respect from
Thank you.
Fogsi.
Thank you so much. Thank you.
Thank you, sir.
Thank you so much, Dr. Sunita. And here we go with the podcast. Justice Mr. Ravi Kumar Tripathi ji is going to speak on reproductive rights of women with respect to MTP Amendment Act and a legal perspective. Before we start our broadcast, let me introduce Sir Tripathi, sir. With an illustrious legal career spanning decades, Honorable Mr. Justice R.R. Tripathi, sir, stands as a paragon of judicial wisdom, academic dedication, and public service. He, having begun his journey as an advocate in 1978, Justice Tripathi's professional trajectory reflects both depth and distinction. Elevated to the bench of the Gujarat High Court as an additional judge in 1999 and confirmed as permanent judge in 2001, he served with honor and clarity of judgment until 2015. Justice Tripathi, sir, is not only revered for his tenure on the bench, but also for his exceptional academic grounding, holding degrees in BCom, that is Advanced Accountancy, MCom, Modern Business and Industry, and LLM in Public International Law. His commitment to legal education began early as a part-time lecturer in 1978 and later as a full-time faculty member in 1996. He has made significant contributions beyond the courtroom. That is very important. He was a former member of the Law Commission of India, New Delhi, where his insights helped shape the legal reforms of the nation. Former chairperson of the Gujarat State Law Commission, Gandhinagar, it was a role in which he spearheaded critical legal initiatives and state-level reforms. A dedicated public servant, Justice Tripathi, sir, also served as assistant government pleader and additional public prosecutor, handling a wide range of civil, criminal, constitutional, labor, and service law matters. Known for his deep involvement in public interest litigations and Lok Adalat, he has been a steadfast voice for justice and fairness. His early discipline and leadership were shaped by his achievements in the NCC, including the prestigious Best Cadet Award and participation in elite camps across India. A passionate community contributor, he has been an active member of the Rotary Club since 1982. Justice Tripathi sir's journey is not just a timeline of positions held, it is a testament to unwavering service, tireless scholarship, and a deep-rooted commitment to justice. So here is with us Justice Tripathi sir, who's going to, we would like to have his podcast, his thoughts on reproductive rights of women with respect to MTP Amendment Act That is legal perspective. Thank you, sir, for making
you.
your presence on a Foxy platform so
Thank you
that
so
our
much.
Foxians and also non-Foxians will come to know the different angles of our MTP Amendment Act with respect to women's health, with respect to women's reproductive rights.
Thank you, Jess, sir. It's really honor to be with you in the same frame,
Thank you.
and I'm sure we will be enjoying the dialogue. Thank you. Thank you. See you.
Yeah. Thank you, Dr. Sunita. Thank you so much. So without wasting of further time, let us begin with the podcast, sir. Sir, actually, this is very practical question. MTP Act was amended in 1921. Lot of efforts of Foxians, senior Foxians, NGOs, and of course patients we required for the amendment in 1921. So there was amendment in 1921. But what amendments you actually think as a legal angle, from a legal angle, that are beneficial as far as women health is concerned, women's reproductive rights are concerned? Because people in India, rather I can say urban area or rural area, they are not aware about the reproductive rights. So as far as reproductive rights are concerned, which amendments you think will be beneficial for the women's health?
Good evening to everybody. And I'll start with Bharat Mata Ki Jai.
Yes, sir.
And with a salute to our defense forces who have brought this peaceful atmosphere for us that we can discuss all these academic questions also. See, so far as reproductive rights of women are concerned, they are basically a fundamental right of women. And Article 15 of the Constitution of India says that there should be no discrimination on the ground of sex. That being so, the women should be entitled for equal fundamental rights, and reproductive rights is one of the very basic right with the women, which should be available to them with infinity. The earlier position was that people were not much aware about this and things were going on. In fact, there are figures which are very disturbing figures, that out of the total abortions which used to take place in the past, about 75 to 80% abortions were to be with the unqualified persons.
Yeah.
And in a very unhygienic conditions, they will get that thing done.
Yes, sir.
Then that used to add to the maternal mortality rate.
Yes, sir.
And that is why the society as a whole, they created a demand that there should be some regularization of this entire process, which basically hampers not only the rights, but even the risk of life is very much there. So that is how it was in 1971 that we have this Medical Termination Pregnancy Act. Initially, when it was made, it was the first step by the country like India in this particular direction. Because as you know, our country is divided into various groups, various religions, various societies which are having different traditions, beliefs, religions also. In some religion, something is very much, right. And in some of the religions, they are a little forward. So they say that, all right, this is tolerable. All those things were there. But then ultimately, the thing was that they were not the things which were properly regularized. And that is why for the first time in 1971, they brought Medical Termination Pregnancy Act 1971. And the act was very short. It was very short to the extent that it had only 8 sections. Section 1 is normally the name of that particular act. Section 2 is always normally the definitions which are used in that particular act. And then Section 3 was when pregnancies may be terminated by registered medical practitioners. So one may feel that whether this particular act was enacted for the purpose of protecting the rights of the women, or they were the act was enacted for the protection of the rights or to remove the difficulties of the registered medical practitioners. But when the law is made, law is always made on the demand of the society. So the demand of the society was that because of the major part of the entire activity of abortion was in the hands of unqualified persons, it was in a very unhygienic conditions and all that. So maternity mortality rate that was causing concern to the legislative wing of our society, because constitution is having three wings. We have legislature, we have
Yes.
executive, and we have the judicial.
Appreciate.
So this was very much disturbing. And if you know little about the jurisprudence of law, you will know that law is always behind by 10 years of the demand of the society. So when there is a demand initially, then it gets mature. And after it getting mature, then the legislative wing takes it up for making a law. So in 1970, they made, and that is where they made that when pregnancies may be terminated by registered medical practitioners. Now, when it was to be given legal shape, they have to provide very strict guidelines for that. That is why section 3. Then comes section 4, places where pregnancy may be terminated. Section 3 and 4, when not to apply. And then came section 5A. Now, this is again an addition because of the latest trend in the society about the privacy. So section 5A particularly deals with protection of privacy of a woman. Now, section 6 is a very formal thing which gives the power to the state governments and other bodies to make the rules for that. And then it also gives section 7 the power to make regulations. And section 8 is very important. The registered medical practitioners will be very much interested in that because it is protection of action taken in good faith. Now, this good faith is a very important phrase. An important phrase because when it comes to you as a registered medical practitioner, this could be very much important defense for you in the court of law that whatever I have done is done in the good faith. So good faith is that particular important term. Now, this medical termination pregnancy act, that started with 1971. And initially they thought that, all right, as the time was prevailing, they said, all right, any pregnancy can be terminated if it is up to 12 months, 12 weeks. So it can be terminated, and that can be terminated on the advice and under the guidance and supervision of one registered medical practitioner. Then they further provided that when the pregnancy, goes further from 12 weeks up to 20 weeks, it can be terminated still with the permission of the, two registered medical practitioners, and on their advice, it can be done. Then, as I was telling you, there was a report in 2015. Total 15.6 million abortions took place. Look at the figure. Yes. 15.6 million abortions took place. And the report is to the effect that 73% of that, of 15.6 million, if you work out the figure, you will be, just amazed.
Which figure? Yeah.
They had taken place outside the healthcare facilities. That is another important aspect of our society, that major part of our population is in rural areas, or at least in semi-rural areas. Very few people are fortunate enough to be in metropolitan cities or good cities where they have good medical facilities. Yes. So in such situation, and with the advancement of the technology, that certain abnormalities of the fetus can be tested only after 20 weeks. Now, if you say that, all right, only up to 20 weeks, you can have the abortion, then the difficulty was that if the abnormalities are detected later, yes, and if they are such of grave nature that the child is going to be a permanent liability on the head of the parents, and not only on the head of the parent, but also to the society itself, because what the child will be having the life as. So that is why they thought it fit that no, it requires amendment. And then they brought amendment in 2021. Yes. And this 2021 amendment, it came with effect after the assent of the president on 25th of March 2021. Now, what did they do in this 2021 amendment? They said that, all right, instead of that 12 weeks limit which was there earlier, it is changed to 20 weeks. 20 weeks. So up to 20 weeks now, one registered medical practitioner can advise and can get the medical pregnancy medically terminated. Then they said that what about after 20 weeks? Because the anomaly or any abnormality will be detected only after 20 weeks. So they said, all right, up to 24 weeks, on the advice of two registered medical practitioners, the pregnancy can be medically terminated. Now, what is important is that, is it that this is the end of the matter? They said, no, it is not the end of the matter. In certain cases, and in certain categories of the women, this time limit will not be applicable. That is very important. And that one must know that this is very importantly provided by the law, because law always tries to take the care of all possible situations.
Yes.
And see, the beauty of law is that they anticipate things and then they provide for those particular things. Similarly, they said that, all right, this is okay, that you said 20 weeks and you said 24 weeks. But what happens in the special cases? What should be the position? Then they said that, all right, the new Amendment Act provides for a establishment of a medical board. And that medical board provision is made under subsection 2C of section 3. So under that particular section, now they have provided that every state and the union territory, they should have a medical board. Of course, one of the criticism of this particular is that in a state like Maharashtra or in a state like UP, where it is so large an area, if you have only one medical board, you know, a lady is staying somewhere in a rural area, and if she wants to get the services of that particular medical board, it will be very difficult for them. So that is again under consideration, and possibly that will be again by some amendment they will say that, all right, it could be for some number of districts or a particular group of districts that they can provide for medical board. So this was provided for the purpose of that medical board can have the examination of that particular case, circumstances and all that. And another very important thing is, of course, very, said on the part of the society that we have so many cases of rape, and some of the rape cases, the victim suffers the pregnancy. And then in such particular cases, to continue with that pregnancy may be a very, serious mental trauma. In such cases also, they said that, all right, no, the things are required to be looked into, effectively. And then we can give the permission for the medical termination of pregnancy. Now, see, the difficulty is when we talk about in high terms, reproductive rights of women. Now, sir, first of all, you know that how many ladies or how many women know about this term right, and then right of reproductive. See, it is very difficult because even today, our education level, you can say, and all that is not up to the requirement level. And that is why it is all very difficult things. But then, ultimately, we have to improve upon. So that is how they have provided for this particular amendment. And by this amendment, a very good effective step is taken in the direction of protecting the rights of reproductive rights of the women. Ideal situation should be that women alone should be having this sole power to decide whether to continue with the pregnancy or not to continue with the pregnancy. But as you know, in the society, and we all are human beings, part of the society, so we all know about the surroundings of the society and what is prevailing in the society. There are a number of factors which affect. In a married couple also, it's not that easy that women can take a decision at any time and can say, all right, I don't want to continue with the pregnancy. That is not the situation. But in such situation, that is why all this periodical timetable is provided. And then advice of the registered medical practitioners is provided for. Then in cases of 2 registered medical practitioners, and in some cases, the medical board also.
Yes.
I think this is introductory part of this reproductive rights of women.
Yeah. Right? Yeah. And I think the women having the serious congenital anomalies baby, and 7 categories of women, which is described in that up to 20 to 24 weeks. These are the women who will get advantages of all this amendment. And they are, of course, because it was not in the past. I know before that there were IPC sections who used to criminalize the medical officer who used to do MTP. But because of Amendment Act, at least these women have certain rescue. Rather, they can go to the health provider, registered medical practitioner, and get the pregnancy terminated. Sir, the second question based on that only, just now we had discussed, in spite of so much amendments, still there are many other, you can say, population or area, they are still not aware of the amendments. So still they come sometimes very late, or even they do not come to us, even the anomaly was serious, and they deliver the anomalous baby. So what effort should we do, or rather your suggestions, so as to increase the awareness amongst our health providers as well as our population?
See, in fact, this is required to be taken at a very, war footing. First of all, the education part of it, and second is about the awareness part of it. I know an NGO working in Gujarat, they are working on that cancer part of it. The difficulty with us is there are so many taboos in our society.
Yes, sir.
There are so many taboos. Even if you ask them to go to the medical, center for examination of certain, parts of cancer and all that, they feel so much, this thing. That NGO takes the entire, the facility to the villages, and after, say 2 or 3 hours discussion with the ladies by the lady doctors, they make them mentally prepare that all right, they will be undergoing this particular test. And after going particular test, if they find that there is require something, some treatment is required or some follow-up action is required, they provide that also. So I think best part is that if we really want to work in this, area or direction, first thing is required the education part of it. Second part is about awareness part. And awareness part cannot be solely done by the government level. Government may just push it. There's no difficulty on that. But unless there are willing people to, spread awareness, that is very difficult. Even on the sanitary napkins part also, number of films and everything is made. In that film only they have shown that what is the taboo. The moment he talks to any family member also, they feel so much offended or so much humiliated. Why is he talking all about this? So in such situation, awareness is very important, and awareness can be only with the help of social, our NGOs and other things. And also, we can take the help of the teachers in this. And especially the female teachers, the lady teachers, they can be of very good help to us, because they can even tell the students of a particular group, age group, that they'll be able to convey to them, and then the taboo possibly will be reduced. And if the taboo is reduced, possibly the things will be moving in a correct direction.
Yeah, and students are very much free. They talk freely to their teachers.
Right.
Their parents, they are very much open up the teachers, because daily they are meeting them. They try to reveal whatever they want to convey to their parents, to their teachers. So there's a good bonding between teachers and the students. That way they will be helpful.
Actually, Dr. Alka, I tell you, teachers bonding is far better than the parents.
Yes.
Because with the parents, what happens? Suppose it's a female child. Then father, she will not be comfortable at all to talking. And she knows that whatever she is going to talk to her mother, she is going to talk to her father. So they feel little, restrained in talking to mother also. But with the teacher, they become so friendly, because that atmosphere is different. And it is at the level of the friendship level, that if teachers develop that particular friendship, they are able to convey to the teacher about their difficulties also, and so many other problems which they are facing, which they are not able to convey to even their parents. So that is very important. And teachers' help we take, teachers' help we are always taking, even in census or even in election, all those duties are there. So possibly the government should make out a scheme that this should be maybe an extra thing, but then this should be considered as a part of the duty, that in a week there will be 2 hours or something they will be devoting for such type of awareness programs. And they should not be only to the classrooms. They could go to the villages also, like Anganwadi, those workers and all that. They can take this particular issue very well. And especially that will be also covering that malnutrition problem also. Because that is also a very big problem in our country, because of the poverty line and all that. And they don't have the resources, but then they can be told that these are the few things which are available without any extra cost to you. And that can reduce your problem of malnutrition. So that can work a very good idea about this. Right?
And same thing can be done in colleges also. The lecturers can very well express what are the means of contraception, because certain times they get married. They are not aware about the contraception means, and they get pregnant, and it is unwanted pregnancy. They don't want a child, and they want to go for MTP, and because of the constraints, because of there is no access to MTP services, they go to some quacks, and vicious cycle from their starts, because they have some problems in the future.
You see, actually, in section 3(2)(b), they have given, after this limitation part, they have given 2 explanations. I'll read little slowly because they are very important. Explanation 1. For the purposes of clause A, which provides for that limits, 20 weeks and 24 weeks and all that, when any pregnancy occurs as a result of failure of any device or method used by any woman or her partner for the purposes of limiting the number of children or preventing pregnancy, the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of the pregnant woman. Now, this particular phrase they have used for the purpose that this is going to put them in a special category.
Yes.
So pregnancy can be terminated in such cases where the question is about, grave injury to the mental health and pregnant women. This is put in a special category. And for
Yes.
that limit will not be applicable of 24 weeks. So even
Yes.
beyond 24 weeks also, it can be, it will be allowed and it will be legal. There will be no difficulty with the register medical practitioners also if this is allowed. And explanation 2 is about that, of course, rape part. For the purposes of clause A and B, where any pregnancy is alleged by the pregnant woman to have been caused by rape, the anguish caused by the pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. Now, you people are, of course, the medical part of it, but in law, when they say that it will be presumed to constitute, that means law is giving so much importance to that.
Yeah.
And nothing will be required to be proved on that basis.
Yes.
That's why this particular phrase is used.
Yeah.
Presumed to constitute, meaning thereby the law will presume itself. Otherwise, what happens? In normal circumstances, when anybody goes to the court of law, he has to prove his case.
Yes.
But in this particular case, law will presume in his favor. That lady or whosoever goes to the court, when this particular phrase is used, presumed to constitute. That is a very important phrase in law, especially because law is trying to help him by saying that, all right, you need not prove. Say, for example, that first one, when they say about that failure of any device or method, they need not come to the court and then prove it that, no, this was because of this. Only their say will be accepted and it will be presumed that it was okay. And they'll be then treated to be a special category. And it will also be presumed that the lady will be suffering from grave injury to the mental health and mental health of the pregnant woman. So this is very important.
Yes, sir. So failure of contraception for the lady and her spouse also.
Right.
So it applies to both spouse, male and female. That is very important addition in Amendment Act. Though presently we say this failure of contraception is indication up to 20 weeks and 20 to 24 weeks is for 7 categories of women. But the word presuming to cause grave injury is something broad umbrella like protection given to health provider as well as patient.
Right.
Sometimes it depends upon the person who sits in the chair, but can definitely get advantage by this particular phrase because it is a like broad spectrum or umbrella like phrase. Next question regarding reproductive rights. You correctly told many people they don't have idea about contraception means, even they don't know what about the reproductive rights. Do you think that we should start telling about the reproductive rights right from the college because they are the premarital group of people? Do you think that we should start educating the girls and boys before they get married about their reproductive rights in colleges?
See, in fact, in one of the program where I was attending, it was said that before allowing two persons to marry, there should be special training and classes for them.
Yeah.
There should be special training and classes for them. And they should be told that with the marriage, these are the liabilities which are going to follow. One of them is that the child is going to be there. So, in fact, education part is very important. And you are rightly saying that it can start at an appropriate age when you know that the girl becomes, now that puberty age and all the questions are there. But then it should be at an appropriate level that she should be told that she has to be cautious about the whole thing. She has to take certain precautions and especially about the hygiene part also. Everything is to be covered. It should be the whole, curriculum should be such that when she's going to be told about the reproductive rights, she's going to be told about the hygiene part of it. She's going to be told about the consequences and all that. And then at college level, it should be full-fledged. Yes. Because college is the maturity level is perfectly, reached. So there will be no difficulty itself.
Yeah. And again, if by chance they skip the session, premarital counseling is also an important part. So before marriage and after marriage, and of course in college days, they can be educated about the reproductive rights and of course the prevention of the pregnancy, or whenever they want, it should be wanted pregnancy. It should not be like accidental pregnancy, so that they will go to again doctor or health provider or certain quack for getting it terminated, and because they want to go for some career or there is some dream that I want to get educated till that level, I don't want pregnancy. So all these things if taught before marriage in colleges, after marriage, post-marital, but before having first pregnancy, that will be helpful for the couple. So this is regarding awareness program. Sir, one question always rather we doctors always saying that because of the Amendment Act, of course, the woman having a serious anomalous baby medical board decides that the pregnancy should be terminated. For that, they take consent of all those four, five kind of people. Medical board constitutes of those five people, five categories of people, and they take permission. And they allow the termination. But my one question is up to 24 weeks, means 20 to 24 weeks, and below 20 weeks as well. The rape patients, because there is pregnancy because of rape, the pregnancy can be terminated. But because the pregnancy has crossed 20 weeks, 24 weeks, but it is a rape patient, she is a rape patient, she has to go into court of law. We know that rape is a crime, serious crime. Again, there's a mental anguish to that girl. First, she doesn't tell anything to any person in the family. One day she tells her mother or father, parents, and they come to know it is plus 24 weeks of pregnancy. In that case, again, the same thing what was previously, writ petition or go to High Court for permission. And that particular part of going to court and then the legal procedure, again, it is a second trauma for the child and of course the family. So can there be any solution? Because till that, Amendment Act doesn't include rape cases about 24 weeks.
No, rape cases are included in above 24 weeks, but then it is treated as a special category, and it could be only with the help of the medical, that board.
Yeah.
The difficulty with us is that, the requirement of the society, they come to the legislative body with a little, late stage. And thereafter, the legislative body starts thinking about it and providing for it. In fact, one of the criticism of this amendment is this only, that as you are rightly saying, that after this particular thing has come to their notice, when they go to the court of law, then the court of law orders for the constitution of medical board, or the victim is sent to the medical board takes its own time. There is a judgment of the Supreme Court which says that the medical board is directed hereby, and that is a direction for all the boards. Within 3 days from the day the victim is approached that medical board. Now, this is how the judiciary tries to plug in the hole which they find that there is in the legislation. In the legislation itself, that could have been provided that the board will be permanent sort of body, and any vacancy will not be allowed to continue. And the state government will be under an obligation to see that the board every time available 24/7. And any person, when he is directed to approach, or if he approaches the medical board, then board will be under duty to decide that particular issue within 2 or 3 days. And the Supreme Court said rightly that 3 days is the appropriate time for that particular purpose. See, the difficulty with us is that ultimately everything boils down to our education and awareness. So these are the two fundamental things which require to be taken care of. And in good old days, even the RM, registered medical practitioners, they used to be as good as family member. They used to be. Now with the specialization and so many, corporate hospitals and all that, that particular culture is gone. Now that position is not there, but still we have a family doctor concept. So you approach the family doctor, then he refers to the specialist and all that. That particular thing is there. But ultimately, about the productive rights also, that family, doctor used to be of very good help. He used to advise properly. He used to, guide them properly. He used to tell them to what particular place the victim is supposed to go. All those things were there. But with this, you can say it's an advancement of the, society or anything, that we have got now the culture of the corporate hospitals where nobody bothers. And there are so many malpractices also we learned, read in the newspaper that puts a little more, cautious about them. Those things are there. But ultimately, the solution with this particular problem is only two. One is awareness program. Second is the education as a whole of the society. And third thing is about that sooner they are told about their rights, they'll be able to exercise it. As I told you, the right word itself may not be known to them. Yeah. If we go to the rural folk, they may not be knowing what is right about it. They only know that, my marriage has taken place and I'm supposed to be, the obedient wife, obedient, in-law, daughter-in-law, and then everything goes on. Even today, when it is a matter of her body, her reproductive health, her mental health, everything, but still, when the decision is to be taken about unwanted pregnancy, the Sasuma will have something to say, the Sasurji will have something to say, the husband may have some very different opinion about that. All those difficulties are there. Yes. But then solution for every problem, you may not find directly in the law. But then it's very good that we have very active judiciary, and our Supreme Court is known for activism, that they always try to expand the things which are required according to the needs of the society, and accordingly the laws are interpreted also, that things are helping.
So there is a procedure which takes time, certain times, and again ignorance, because of that the child comes very late to the health provider. But there is of course Supreme Court is there and wide expansion of these definitions to give help to this poor child, a poor girl who is already raped and having some mental trauma, definitely, and of course the family also suffers. Sir, one question little bit different from this. Adolescent pregnancy, generally it covers, this POXO Act applies, but sometimes I have seen in between 16 to 18 weeks, 16 to 18 years of age, sometimes court allows the pregnancy, the child wants to continue the pregnancy, irrespective of parents' no. We have seen cases in the past where court says if the child, 16 to 18 years of child, and she wants to continue pregnancy. So is this okay as far as current or society's structure is concerned? What is your opinion, sir?
See, in fact, this is very individual case will be. It all depends upon the that adolescent, that victim or the mother is that you are talking about. Maturity part of it. Yeah. Whether she knows about that, whether she will be able to bear this liability in all days coming, or she will be in at present, she may be in a very different, frame of mind. And therefore, she is saying that, no, I want to continue with that pregnancy. But then she has to know that whether her family is going to support, whether the, partner you say can call it, whether his family is going to support. And all those things are required to be told to her. And that is why we have also that social consultation part of it. And there are, paralegal volunteers who can explain to her all this difficulty. And with all our, legal aid clinics, which we are having at the district level, they also have the paralegal volunteers. And these paralegal volunteers are the students of law colleges. Yes. So they know about the law, and they can also tell her that these are the difficulties which you are going to face. And until there is some good assurance to her, I think she should be advised that no, your decision you are required to reconsider. Yeah. So I think these are the voice from legal aid services. What we have, our law colleges have, they go to these patients or these families and counsel them. After that, if they are ready, then they can, of course, the court sees all those things, whether she can bring up the child, whether the facility, economy, all these things are taken into consideration. Then only in exceptional cases, I think court will give the permission. Yeah. Otherwise not. Yes. So one question is there regarding Section 5 of the MTP Act, Amendment Act. Yes. Previously, it was actually breach and privacy. We have discussed about this privacy and breach. Right. One thing that we health providers are under so much of pressure that we try to maintain secrecy, privacy. All these things are followed in our day-to-day practices. When we note down the patient, when take the consent form, fill the register, etc., etc. But what if the privacy is breached by the patient's relative, patient herself, or anybody who is in contact with the patient? Because the privacy clause previously it was in that fine of rupees 1,000, but then the Amendment Act says fine and imprisonment. So 1,000 rupees fine is hardly anything, but imprisonment is such a shocking or terrible condition for the health providers, and breach can be anywhere. Even if we try to keep it privacy or secrecy, sometimes any relative can speak, yeah, madam, this maji MTP karun dili, ichi MTP karun dili. But we are not responsible for that. Right. We never told. So what, there should be some clause for this thing also. Yeah, right. See, first of all, I'll invite your attention to Section 5A, yeah, because that is also added by this Amendment Act. It says protection of privacy of a woman, right? No registered medical practitioner shall reveal the name and other particulars of a woman whose pregnancy has been terminated under this act, except to a person authorized by any law for the time being in force. That is the provision. Now, you are rightly saying that that particular, privacy is leaked or that is breached, that particular aspect. Then what happens? Whether registered medical practitioner will be held responsible for that. See, for that, subsection 2 of that Section 5A is, whoever contravenes the provisions of subsection 1 shall be punishable with imprisonment which may extend to 1 year, or with fine, or with both. That is what you are more worried about, because it says about the imprisonment also. Fine part, I can understand that the doctor will be saying, all right, Even if it is little higher, no difficulty on that. But the chances of misuse of this particular provision is more at the level of, I should not say that, but then it is a hard reality of life when it comes to an investigating officer or investigating agency.
Yeah.
But then the registered medical practitioner has to be little, I'll say bold, and he should keep his papers ready for showing to the investigating officer that all these particular formalities which are mandated to maintain the privacy was maintained. And this particular privacy, if at all it is breached by some other, you can say person or relative of the victim or somebody else. Then that other phrase which I said in the beginning, in good faith. So the RMP can always, register medical practitioner can always take shelter of that particular phrase of good faith. You can say that all these things were maintained and all these things were conveyed to the at least victim and her relations. So it will be, see, I tell you, Dr. Alka, that it will be for them to prove that it was breached at your level. That is also important.
Yeah.
What happens, see, you must be hearing all these days about the cyber fraud and all that.
Yes.
I'm telling that I've never come across any such call. Right. Suppose a call comes that you send some register parcel and that drugs are found in that particular one. But if I have not sent at all any parcel, why should I be worried about? And educated people also fall prey to that because either they have sent some parcel or they have indulged in some other activity which they feel that no, this could have done that. Otherwise, this cannot happen. So in this particular case also, a registered medical practitioner should be little bold enough to hold his stand that no, I perform my part of duty. It is not breached at my level, and let the investigating officer inquire whatever they want to inquire, and let all papers be placed before him. And ultimately, it is for the court to decide. And I tell you, and I can say this with all responsibility, that courts are not averse to the registered medical practice, not at all.
Yeah.
They always look into it very differently with all responsibility that ultimately he is a very responsible person or member of the society. So don't be, totally disturbed by that particular thing. And I tell you this particular provision when it says punishable with imprisonment which may extend to 1 year. So it could be 1 day till the rising of the court. That is one. Second thing, or with fine. So there is no imprisonment, only fine. And then it says or with both. So then it all depends upon the material which is placed before the honorable judge. And if he ultimately comes to the conclusion that no, definitely it is breached only at your end, then he has to decide about this particular punishment part, not otherwise. So my advice to all registered medical practitioners is to, of course, little it is tedious also, little it is burdensome also, but they should maintain their papers very, meticulously. And all those things, for that, they are required to, sacrifice 10 minutes. They should do that. And with that, there will be no difficulty on that. But otherwise, this is a very important, aspect. And if recently in one particular case, the police officer of a very high rank, he was briefing the press conference and he disclosed the identity of the rape victim. So they may be slips, but that cannot be made a rule of law. So that is why in the matters of privacy also and breach of privacy also, doctors should not be totally worried about that. But only they have to maintain their particular, procedure which is to be followed at their end. The rest of the things are taken care of by the investigating agency and also by the courts. So don't worry about that.
Yeah, exactly. Actually, the burden of proof shifts to them that who has violated.
Right.
Because many times we are under pressure, tremendous pressure, because we do everything, but something is leaked. Again, the doctor will. But what you told correctly. But sir, one thing I wanted to just request rather, why it was imprisonment was added, because there was already fine was there, but the addition of imprisonment added more of pressure rather to our health providers, because something can be breached by anybody, not doctors as such. Yeah.
No, then you're right. You are right. But then, as I told you, that sometimes these all things come, with the, total, you can say survey or reports, that these are the things which are reported. Now, what happens, when it comes to us, we only think according to ourselves, that how are we doing? We strictly follow law. Even at the traffic signal also, you don't breach the signal. But there are people those who are breaching that particular thing. And that is why that particular, provision is required to be made. So it is not specifically for any particular registered medical practitioner, but then it is put only with the view possibly to put them more on a guard that this will not be. And that is why, see, they have said that which may be extended to 1 year.
Yeah.
Meaning thereby, it could start with the rising of the court.
Yes.
1 day, 2 days, 3 days, 5 days, 7 days. And then it says only with fine. So then everything is given to the good senses of the honorable judge who is going to ultimately handle with this particular case or with both. So this imprisonment part, possibly it could have been avoided also, I don't know. But then you are thinking according to yours. But you think about those fake doctors.
Yeah.
Fake doctors, what to do about them? And they are not in 1 or 2, they are in numbers.
Yes.
They are in numbers. So possibly that is the reason, not otherwise anything against the medical profession.
Registered medical practitioners, they are always protected by law.
Yes.
And judiciary is always in their favor, provided they follow the MTP Act in spirit.
Of course. And same thing is with that PNDT Act also. PNDT Act also the same thing. Because of our society's, the fabric, where everybody wants a male child, nobody wants a female child. How can this happen? I don't know. And why should he interfere with this, system of the nature, which has made that it will be by many this thing. Otherwise, if they wanted to regulate it, they could have given something in your hand that no, you will decide that whether it will be a male child or female child.
Yes.
So people should also be educated to that. And now, of course, the things are changing. That issue also, which used to be 1,000 to 800 in Haryana or somewhere. Now it has come down, I mean, specifically improved upon. So that way the things are changing. And still it will take some time to get changed. Don't worry about that. Don't worry.
So usually there is one saying, law or government intervenes whenever there is imbalance.
Yes.
Otherwise, who has got time to intervene?
Yes.
So when there is some imbalance, the government or law, judiciary people see, then only try to rectify, and because of that, new amendment or new legislation is there. So
see,
if it,
Dr. Alka, problem is, law is always meant for correcting the course of conduct of the society.
Yes.
So if the society doesn't conduct itself in a, against the law is not required. The law is only for the people, those who are going to conduct themselves against the law. That is why the law is required. And the law is not going to be effective unless there is a sanction behind it. One of the definition of law in jurisprudence is that law is a command of the sovereign, which has the, sanction behind that. If you are not able to do anything, I need not go to that particular area, but then what happened with our neighbor country? We have to express our strength, we have to show. So until there is a sanction behind your command or that particular, wish, it is not going to be effective. That is why possibly it is made like this. And in good old days, we had the systems now. If a female child is born, she will be put in that milk pot.
Examples in the past. Yes.
There are instances, especially the Rajasthan or all those cases which used to be, we did. That was very shocking. Very shocking. And the whole thing is, we think about the entire society according to our standards.
Yes.
That is not so. There are people, those who are, just, no rules are applicable to them.
Yes, I know.
No rules are applicable to them. That's a problem.
Correct. So last question, very important question, because whenever MTP Act 1971 and the recent amendment, everywhere talks about the registered medical practitioner, registered place, and if the case is as per the indications in Amendment Act, MTP Amendment Act. So many times we say it's a right of woman to get pregnancy terminated, but this is not absolute right. Again, because many people talk about right of the woman, but these are again not absolute. These are the passive rights. What we talk about fundamental or constitution, these are the rights given to women. But do you think, or do you want to say, or whether something can be there that woman can undergo MTP irrespective of indications, or it will be like the law will not be followed properly? Is there any fear in the judiciary's mind? That's why the indications are given. Then it is a passive right. It doesn't become absolute right. Unless it is an indication, we can't go for MTP, or the patient cannot undergo MTP.
See, Dr. Alka, the problem is, ultimately, this is not a pure legal problem. This is a socio-legal problem.
Yeah.
And socio-legal problem can always be solved or can always be addressed with the necessary actions or conduct on the for the improvement of the society also. See, ideal situation should be, it should be to the women alone that whether she wants to continue with the pregnancy or she doesn't want to continue. Her mere word should be sufficient that, all right, I don't want to continue with this pregnancy and there should be no other restrictions. But then the difficulty is that we should have that mature society, that mature, female, folk, that they will be knowing about all this. As you are rightly saying, this will be ideal situation. But by the time we approach that particular ideal situation, these are all the, on the way efforts to improve upon the situation which was prevailing in the society. See, I tell you, the entire MTP came into existence only for two reasons. One, mortality, rate, women mortality rate. And the second thing was about these consequences about with the advancement of the technology, we are able to now know that fetus is going to be not only burden, but it will be, for all time to come before your eyes, and it will be agony which will be undergoing. Now that facility is available. So that is why we thought of that it should be there. But then simultaneously, we also have a counter problem of selecting the, sex of the fetus.
Yes.
So that is required to be balanced between the two. To see that it is not misused, they have provided certain guidelines. And that is why it is rightly said that amendment is in a right direction, that we have liberalized. We have taken care of about that advancement of technology also, because up to 20 weeks, there was no possibility of ascertaining the abnormalities. It was only after 20 weeks that you are able to do it. Therefore, they made it all at 24 weeks. Thereafter, they provided for the special categories of the women, that if it is a failure of contraceptive, or if it is a rape victim or something like that, then it will be a special case and it will be treated specially. And possibly only last week there was a news item. Supreme Court or they permitted the medical termination of pregnancy at a very advanced stage. Very advanced stage.
Yes.
Only seeing this particular thing. Because I tell you one thing, at the judiciary part, I can definitely tell you that we always have the welfare of the women at the top priority. At the top priority. If we feel that no, there is a small risk to her life, we'll say that no, don't continue with this particular pregnancy. Let it be, terminated. No difficulty in that. But at the same time, suppose that termination is under the pressure of the society. Her sasu may saying something or something like that. She's already having 3 female children and now she's having again, 4th. They don't want that particular risk to take. All those difficulties are going to be there. So ultimately, solution is going to be, as we said in the beginning, awareness and education too. And as you were rightly very saying that at the college level, at the appropriate high school level also, we'll have to start teaching our children about this. And until they are told about, and I think it is not a very idealistic suggestion that there should be classes or training for the before marriage and after marriage also, before first pregnancy. In fact, that is very much required because people just don't know. They only feel that it is fun. And they realize that particular fun to be very, burdensome only after it is, irreparable position it is. So that is why it is very much required. And I think the law is not static. It is always dynamic law.
Yeah.
So with the changes of this thing and the institutions like you, that Fogsi or something, you can always put it continuously on the health ministry and all that. No, this is still further required to be improved like this and all that. And with technologies, we don't know. If there are some technologies which are going to help in this particular direction, the law will be amended. Law is not something which cannot be amended at all. 1971, we came for the first time with the MTP. Then it was in 2021 that we have come with this. So with this improvement, further things are going to change and they will be improved upon.
Yes. In fact, sir, we are the proud citizens of India. The law is so much liberalized in India and MTP can be done very safely. There are other countries where they still consider MTP and they continue pregnancy and there's something happens, they go to quacks. So this is the proud country, rather Indians, we are proud that there was amendment, and looking at a scenario, law is widened so that the judiciary and of course government, they take our opinion and they broaden the law or they give some additional technology to diagnose the condition and so the terminate the whatever patient thinks, whether it is a burden for the society or something else. So depending upon the scenario, the law also changes. As you have said correctly, sir, law is a dynamic. So depending upon the requirements of the society, judiciary and of course executive and government takes initiative and they amend the law. So we are coming to the end of our discussion, sir. Wonderful insights from you. And actually, reproductive rights is such a huge topic. When I had done LLM in criminology, sir, that time
Okay.
I had taken this along with PG diploma in human rights education. That was the topic for my thesis, reproductive rights of the woman. And
Okay.
that time I read it thoroughly. Then I came to know where we stand, where our people are, where our Indian woman, whether she understands what are the reproductive rights and what are the rights regarding MTP and all that. So thank you, sir. Sir, before just closing our discussion, just take a message for our healthcare providers regarding today's topic and whatever you want to advise, sir.
See, I want to advise one very important thing. Try to make the relations on a personal basis. Though we have entered in the era of the corporate hospitals, but still we have a little, system of family doctors. So these family doctors have a very important role to play in the society. They can keep them, take them in confidence. They can advise them properly, and their advice will not be taken otherwise. If somebody else advises, it is very difficult. Sometimes it gets the person gets offended that why should he advise at all? And if the child from our family who is a family doctor, who they are addressing right from the childhood, uncle or something like that, then if they advise them, it is very important that you people can play that particular important role. All those problems about, attack on doctors and, some dissatisfaction and all that, that is all because that personal touch is, shattered. So that is the difficulty. I request and wish you all good luck to all registered medical practitioners, not only in this front, but all other fronts also, that they should contribute maximum beyond the, the limits they have drawn. They should try to contribute beyond that. Correct? That will be very useful for the society. And you are rightly saying that we are proud citizens of proud country of India. And, that's a real, in fact, it is coming from our, heritage. Yes. It is coming from our heritage. We had very good, bright past where the doctors and even Vedic village, he was, treated as a very respectable person in the society. So we, as I'm telling my advocate friends also, that you should try to restore the position of pre-independence, when our independent fighters were all 60-50% were advocates. So is the case with the doctors also. Doctors have always been the main pillars of the society. And today also, you go to little, suburban area, and if you ask any family what do you want your child to be, they'll say it's a doctor. They'll say the doctor. So that's very important.
Still, there is respect for the doctors.
Yes.
Society members, and they are doing good work, actually noble work.
Of course.
Yeah, and certain things we have to follow when we want to conduct our practice smoothly and remain.
I don't know whether you have this book. You can have this book. It's very useful book for the purpose of especially the women's right and all that. It also covers the children right also, but otherwise it's a very good book. If you just go.
Published by printer, sir.
This is published by the EBC, that is Eastern Book Company.
Yeah.
Eastern Book Company, EBC they call it.
Okay, sir. Thank you so much. Definitely we'll go through it. Yes, sir.
Okay.
So once again, thank you, sir, for your beautiful informative insights on the topic. Very difficult topic, but of course, we the gynecologists are there, and our patients are like they are our relatives. So if we follow the law and the intricacies of the law, we know, and some awareness and education, of course, is there, and we try to conduct our patients treating as if they are our relatives, so that our conduct is also good, and whatever work we are doing is a noble work. So thank you, sir, once again for rather obliging this. You are like you followed my this invitation. I invited you, and immediately you said yes for the invitation. So on behalf of Fogsi, I'm thankful to you, and of course thanks to my president, Dr. Sunita Tandulwadkar, and of course Evangel team, Rohit and Krupa, for the wonderful technological work they are doing. And we are meeting new people like this, those who advise, those who are there for us to protect us and to guide us whenever the emergency is there. So thank you once again, sir. Thank you, sir. Good night, sir.